Okay, we on the record in cause number 135642, and the court has before it a petition for occupational driver's license. The case is styled ex parte James Thompson. Mr. Thompson's petition was filed by attorney Thad Thomason, and Mr. Thomason is not appearing today. However, attorney Arnella DeSeta is appearing for Mr. Thompson in regards to this petition for occupational driver's license. And Mr. James Thompson is not appearing, but he's appearing by attorney, Miss Arnella DeSeta. We also have present Mr. Raymond Shearer, who is Assistant District Attorney for Jefferson County. Now, Ms. DeSeta, I have the petition before me, and I think you stated that the state was not opposed to the granting of the occupational driver's license. Is that correct?
That's what I was informed by my supervisor, that Thomason, he says he spoke to, my understanding is he spoke to Mr. Ray Shearer, and that was the understanding.
Okay, Mr. Shearer, you've had an opportunity to review the petition for occupational driver's license, Mr. James Thompson.
Yes, Your Honor. And also in the meantime, I was able to locate the cases that were filed before this court on the criminal side.
Okay. And if I'm not mistaken, that case, which is well, you have a DWI with a Brett, with an alcohol concentration of 0.15 or more, and I guess it's unlawful carrying a weapon. Those are the two cases you're talking about?
Yes, Your Honor, they are.
And are those cases, if I'm not mistaken, are still pending?
Yes, Your Honor, they are. I think they have a docket setting of the 26th of next month.
26th of next month? Okay. Okay, so regarding this petition for occupational driver's license, what is the state's position?
Your Honor, the state has read this over, and there are very few concerns the state has about this, understanding that Mr. Thompson needs to work and needs to be able to commute to work. The only thing is, I don't know if we just did not receive the attachments for the SR 22 and the DL abstract, but then also because of the alcohol level that we, when we got the lab results of actually 0.167, the state feels like that there should be language in the ODL for the interlock device.
Okay. Okay, now I do have a copy of the his driving record. That's in the file.
Okay.
And I think there's a SR 20. Yeah, I saw that in here too somewhere. Yeah.
Okay, well, then that's understandable. That just means that I never got that copy. So as long as that's in order, then the state's not opposed to that.
Yeah, matter of fact, I have it from Geico, and it shows that his insurance is in effect up until April 16th of 2021.
Okay.
Okay.
That's correct,
Now,
Your Honor.
okay, now, and first of all, the court is going to take judicial notice of the filings in this case. And looking at the court's, looking at the petitioner's petition, the court will state that on this day, January 13th of 2021, the court heard the petitioner's application for occupational driver's license, and the petitioner appeared through attorney, and in this case, it's Miss Ornella DeSeta, who is representing the petitioner. The court finds that the petitioner was arrested on or about February 6th of 2020 in Jefferson County, Texas, for the offense of driving while intoxicated, which is a DWI, and he refused to provide a specimen of his breath or blood, and as provided in Chapter 724, Subchapter C of the Texas Transportation Code, petitioner license was suspended for a period of 180 days. Petitioner has not had a prior suspension arising from an alcohol or drug-related enforcement contact as defined by Texas Transportation Code Section 524.001 in the 5 years preceding the date of this arrest. Petitioner has not been issued in the 10 years preceding the date of the filing of this petition more than one occupational driver's license due to a conviction under the laws of this state. The court finds that it has jurisdiction and venue over this case and the petitioner because the offense for which the petitioner was suspended happened in Jefferson County. The court finds that the petitioner has provided the court with the following: a certified abstract type AR of petitioner's driver's license record and an SR 22 financial responsibility insurance certificate. The court finds that the petitioner's driver's license is suspended because the petitioner refused to submit to a breath or blood test as submitted a test or blood test that registered more than 0.08 following an arrest on February 6th of 2020. The court finds that petitioner's driver's license is not denied, suspended, or revoked because of a physical or mental disability or non-payment of child support. The court further finds that petitioner has been issued more than one occupational driver's license following the conviction during the past 10 years. The court finds that the suspension of petitioner's driver's license began on, let's see,
I believe it was August 25th, 2020.
August 20th.
That's what the order says.
I'm looking at it. It's August 26th of 2020, and it ends on February 21st of 2021.
Right, so it's only like a month and a half away.
Yes. Okay, and the court further finds that the petitioner is currently employed as a production operator for, is that Cheniere Energy?
Let me turn this off. Let me recheck.
That's
I believe, yes, production operator for Cheniere Energy, 700 Milam Street, number 1900, Houston, Texas, 77002.
Okay, okay, so let me repeat this. Petitioner is currently employed as a production operator for Cheniere Industry, which is located at 700 Milam Street, number 1900, Houston, Texas, 77002, and must be available to drive for work-related duties anytime between the hours of 5 a.m. to 5 p.m., Monday through Sunday. In order to perform his duties, petitioner is required to travel in and between Harris, Jefferson, Montgomery, Chambers, Liberty, and Galveston counties. Petitioner income from this trade is his sole source of income. Moreover, it is necessary for petitioner to perform certain essential household duties for his own welfare and maintenance. Petitioner must also be able to attend all court-ordered activities. And the order, under the order of the court orders that the petition for occupation driver's license is granted subject to the following restrictions, and orders petitioner to follow all restrictions listed below. The court orders the Texas Department of Public Safety to issue an occupational driver's license to petitioner subject to the following restrictions. The court further orders the Texas Department of Public Safety to administer any and all tests required for the issuance of said occupational license, and if petitioner passes all required tests, issue an occupational driver's license to petitioner subject to the following restrictions. Petitioner must not drive a commercial vehicle with this license. Number two, petitioner must maintain in full force and effect an SR 22 automobile liability insurance policy for the entire period the occupational driver's license is in effect. And three, petitioner must have in his possession a certified copy of the court order while driving, and must allow a police officer to examine the order when requested. The court also orders the restricted, as stated below. The vehicle owned or operated, any vehicle owned or operated by a petitioner must be equipped with a working ignition interlock device in accordance with the Texas Transportation Code section 521.2465. And a petitioner must not refuse any lawful request by law enforcement for a sample of petitioner's breath or blood if stopped for driving while intoxicated. Petitioner must and pursuant to the Texas Transportation Code section 521.245, the petitioner must attend counseling and rehabilitation services. The petitioner may attend one of the following court-approved counseling or rehabilitation services and return proof to the court upon completion. You could attend 8 hours of private counseling and rehabilitation services within 60 days. We had two other ones on here, but I don't think they're no longer in effect, which was ATOR. With that was local, and he doesn't live in Jefferson County anyway. So he has to attend.
Yeah. He lives in Beaumont.
He lives where?
No, this might be no, maybe this is not an update. No, he probably lives in Houston. That's where he works.
Yeah, that's what I see. He lives somewhere in Webster.
Yeah, okay.
Yeah, so he would have to, the petitioner he may attend, he has to attend an 8 hours of private counseling and rehabilitation services within 60 days, and he needs to provide proof of that attendance and completion, the proof of attendance and completion to the court.
Okay. Just any private counseling or?
Yeah, it could, for drugs and alcohol.
Right.
Alcohol, yes.
Just any, okay.
Yeah,
okay.
Just you need 8 hours.
Would it be like if he were to do AA classes and he were to do 8 hours of that, would that be sufficient?
I think that we may have to do that now since we don't have ATOR, but it could either be a private counseling and rehabilitation, or if he can do alcohol, the AA meetings, 8 hours.
That's good too.
Okay, he can do that as well.
Okay.
Now, let's see. And he may only drive in those counties that I've mentioned earlier. And those counties, let's see, and the counties that I mentioned were Harris, Jefferson, Montgomery, Chambers, Liberty, and Galveston counties.
Okay.
And petitioner must only drive to and from work or school and for essential duties, including medical appointments, court appointments, attorney appointments, probation office meeting, and any supervision, education, counseling, or other educational needs authorized by this court. And the hours in which he'll be required to drive, I think you listed in the petition, are these his work hours from 5 a.m. to 5 p.m.?
Yes, it says here 5 p.m., 5 a.m. to 5 p.m.
Is that, will he be, I guess and that's Monday through Sunday?
Monday through Sunday, yes.
Okay, state, you have any objections?
No, Your Honor, especially that the hours at 5 p.m. end at 5 p.m. Therefore, the typical nighttime drinking and driving hours are out of the way. And it's
Okay.
noted that the incident that caused this arose about 3 o'clock in the morning. So this would protect the state of the citizens in that respect.
Okay, now, is the state requiring that he always keep a logbook in his car?
That's usually a situation, but if we do have the interlock, then the interlock itself
Right.
acts as basically a log. So
Okay,
we would waive a logbook since if he does have the interlock in his car.
okay, all right. Now, the date of this order takes effect, the court clerk shall send a certified copy of the petition and the court order setting out the court's findings and restrictions to the Texas Department of Public Safety. This order takes effect on the date the order is signed by the court. If all driver testing requirements have been met, petitioner may use a certified copy of the order for occupational driver's license as a restricted license only for 45 days, beginning on the date the order takes effect. The date the order ends, unless revoked by the court, this order for occupation driver's license remain valid through I guess it's through May 21st of 2021. That's when its suspension ends.
No, Judge, you mentioned earlier that the suspension ends February 21, 2021, because it began August 26, 2020, and you said it was 180 days. And then I believe you said it ended February 21, 2021.
Okay, so this, let's see, unless revoked by the court, this order for occupation driver's license remains valid through February 21st of 2021, which is the date the petitioner's current driver's license suspension ends. And the reason for the petitioner's current driver's license suspension is listed in number 4 above. Now, the warning to petitioner, it is a Class B misdemeanor for you to drive in violation of any of the restrictions listed above. It is a Class B misdemeanor for you to drive without a certified copy of this order in your possession, and the court may revoke the order at any time for good cause. This order and your occupational driver's license are automatically revoked if you are convicted of driving in violation of any of the restrictions listed above, or convicted of driving without a certified copy of this order in your possession. If all driver testing requirements have been met, you may use a certified copy of the order for occupational driver's license to drive for 45 days only, beginning on the date this order takes effect. If you do not receive your occupational driver's license from the Texas Department of Public Safety before the 45th day after the date this order takes effect, you must not drive until you receive your occupational driver's license from the Texas Department of Public Safety, or come back to court to get an amended order for occupational driver's license that extends the 45-day time period. It is this order, well, if this order includes a finding of an essential need to drive and the places, reasons, days, or times that you need to drive change, you must come back to court to get an amended order for occupational driver's license that reflect these changes. And this is the order of the court. Okay, so.
Thank you, Judge. And where can I get the certified copy of your signature so I can give that to the client?
Well, we're gonna have to draft up the order, and then we can send it out to both you and the state.
Okay. And so I'll look
Oh,
out
now-
for that in a couple of days.
Okay, now, Mr. Shearer, was there anything else that was, did we leave anything out of the order?
Not, I didn't notice anything, any omissions, Your Honor.
Okay, and Ms. DeSeta?
No, Judge, you got everything. So Judge, I just want to make sure I understand from everything you said. So it's granted today, the ODL. He can drive for the next 5 days as long as he met all the requirements. And then
No, I think it said 45 days in here, but there's a, when we get the order out, let's see. Let me see if I can find that in the order.
you said something about 5 days to receive the ODL.
No, I'll give her a call at home.
So,
Okay, let me,
so does my client have to wait until we get the signed order for him to be able to drive?
well, because you have to have the signed order with you.
Right,
Hey.
okay.
Let's see,
No, I'll call you at home. So make sure I got your book. Okay, well then you call me back in an hour.
okay, let's see. I see here that the date that the order takes effect, it states that if all driving test requirements have been met, petitioner may use a certified copy of this order for occupational driver's license as a restricted license only for 45 days, beginning on the date this order takes effect. So as a requirement here, say that if all driving testing requirements have been met. And I think in this order,
So Judge, are you saying that we'll just wait for us to receive a copy, me and the state receive a copy of the order, and then we can proceed?
hold on a minute, there's, I see, okay, in this order, it states that on the order, the court orders that the petition for occupation driver's license is granted subject to the following restrictions and orders petitioner to follow all restrictions listed below. The court orders the Texas Department of Public Safety to issue an occupational driver's license to petitioners subject to the following restrictions. The court further orders the Texas Department of Public Safety to administer any and all required any and all tests required for the issuance of said occupational driver's license. And if petitioner passes all required tests, issuing occupational driver's license to petitioner subject to the following restrictions. And one of the restrictions is that he cannot drive a commercial vehicle with this license. The other one is he has to, the SR 22 has to remain in full force and effect during the pendency of this occupational driver's license. And he he must have in his possession a certified copy of the court order while driving, and must allow a peace officer to examine the order when requested. And there are some other restrictions here that I had stated earlier. So I think what we need to do is we'll send you a copy of the order, and then you can look at the order and follow the order as it is written. Did you hear that?
You don't give me judge or
I said we'll send you a copy of the order, and then you'll follow the order. Y'all can follow the order as written.
okay.
The order is kind of, I say, self-explanatory, but
Yes.
once we get the order to you, you can read the order, and then you should be able to advise your client as to
Yes.
what he can and cannot do based on the court's order.
Will you be sending it to me via fax or email? Just so I can look out.
I don't know. Let me.
You need my fax number. I have it.
Okay, what we don't want to do, we don't want to put it over, we're on YouTube. So I'll get it from you once we get off of YouTube. And I think we have an email address for
Me.
Mr. We have an email address for Mr. Thomason.
Okay, that would work. That if you send it there, that's perfect.
Okay, State, you have anything else?
No, I just make sure that Ms. DeSeta understands that he has to have that order when he's driving. And I know that in the past, the Department of Public Safety would also issue a driver's license looking device that says occupational driver's license, but because of the COVID conditions and stuff and the backlog of just even renewing driver's licenses, I don't know if that's even possible for him to get that from DPS, but it's certainly, if he has that order, then he should be good.
Okay, thank you.
All right, we'll, okay, so this will conclude this hearing.